Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about Chapter 13 bankruptcy, and I'm joined by my co-host Jesse Barrientos and a special guest Isabella on set today. Jesse, welcome to the show.
Thank you, Dave.
Now, Jesse, you have been practicing bankruptcy for some time, both Chapter 7 and Chapter 13. Most people know that Chapter 7 is a fresh start over kind of case. But today we're going to be talking about the lesser-known case, which is Chapter 13 bankruptcy. What is Chapter 13 bankruptcy all about in a nutshell?
In a nutshell, Chapter 13 is basically a consolidation or repayment plan. What it does is it consolidates the actual legitimate consolidation of all of your debts, secured and unsecured, and it's paid. And after the plan term, it could either be 36 or 60 months. So that's either 3 years or 5 years or any place in between, depending upon the unique situation of the debtor, until it's paid off. And then when you're out of the plan, it's done. And people can pay either, as little, we're talking about the unsecured. We'll talk about that a little bit later.
Let's talk about the most common use of a Chapter 13, which is to save a home. How is Chapter 13 beneficial to a homeowner who may have a home in foreclosure or have fallen behind on the mortgage?
A lot of times we'll see that people will come in and there's a sheriff's sale that's looming around because they've already gone through the foreclosure and everything else. And so they want to be in their home. They don't want to be dispossessed of that home. They've been there. They need to have a roof over their heads, their children's heads, and everything else. So basically what that's going to do is it's going to stop the sale from proceeding. And a lot of times people are in arrears. We talked about it with the Chapter 7. As long as you're not in arrears and as long as you fall into other situations and you qualify, you'll be able to do a Chapter 7 even though you have a home and you don't have too much equity or anything like that. However, with the Chapter 13, a lot of times people have a huge arrearage and they have not been able to get a loan remodification from their lender.
Now, the arrearage is the portion that they have fallen behind on their mortgage.
That's correct.
And that's the portion that you can repay over time, over a 3 to 5 year period?
That's what happens. They will include that, and that's a secured debt, obviously, your complete arrearage, and they will also include, for example, if you have an automobile that you own and it's not leased, and that you have, whatever, maybe $15,000, whatever it is on it, what's going to happen is that whole amount is going to be included in the plan. And what you're going to have to do throughout the term of the plan, whether it's 36 or 60 months, is to be able to pay your secured creditors 100%, and your unsecured creditors, which would be credit cards, those kinds of things, as little as 10% and as much as 100%, depending upon the available income that's left after your allowable expenses.
So the amount that you pay in a Chapter 13 is based in one part on how much you have available per month, income minus expenses.
That's correct. And sometimes you might be in a situation where you can't file either a Chapter 7 or a 13, the in-betweens. There might be a situation where there's not quite enough income left over in order to fund the plan within that, the 60-month, which is the limit there, to be able to fund that and to be able to pay everybody off like you're supposed to. And so in a situation like that, there's really only one thing that's going to help you, and that's either more income or less income. And maybe you might be able to do, well, if you do a Chapter 7 and you owe something on your house, unfortunately you have to make that decision of whether or not that's going to be a good thing for your family.
Why would somebody want to do a Chapter 13 as opposed to getting a fresh start under Chapter 7?
Well, they might want to do it because a lot of people feel like they feel bad. And people come into my office and they tell me, and they feel really embarrassed that they have to have some kind of assistance and some kind of help. And they really want to pay their creditors. They've always paid their creditors all their life, but things have happened. For example, maybe it was a divorce. Maybe it was an illness that was unforeseen. There's all different kinds of things that could happen. They lost their job. All of those things come into play. And so for the first time, they find themselves in uncharted territory. And so they really want to pay them back. And so they feel a little bit better about that. But generally, if you don't qualify for Chapter 13 and you can't pay that back, I mean, you're in that unique situation where you might have to look at some other options. I want to talk just a little bit, and maybe you can help me about that. We talked a little bit earlier about the consolidation, there's a lot of companies out there that are telling people that their debts can be consolidated and without filing a bankruptcy.
Consolidated and paid back for less than the total amount due.
That's right.
Yeah, there are a lot of companies like that, and you have to be careful, Jesse, because a lot of those folks, debt settlement companies, are taking a fee up front from an individual before they've even paid or settled anything with the creditor. So it's kind of a way where some people think they're going to end their debt nightmares and their financial problems through a non-bankruptcy remedy, but they should be very careful because those debt collection companies, debt settlement companies, don't have the ability or the strength that attorneys have under Chapter 13 bankruptcy laws. For example, a debt settlement company cannot force a creditor to accept a settlement. So let's say half the creditors agree and half don't. The individual who thinks he or she is paying off their debt can wind up being sued by one of the companies that won't accept the settlement. Whereas in Chapter 13, they either have to accept it or the debt's eliminated. So it has a lot of strength in Chapter 13 that does not exist in debt settlement.
Well, what happens, so basically Chapter 13 is the true consolidation that has some teeth behind it.
Chapter 13 is the absolute bottom line debt consolidation, reorganization plan, where if creditors don't want to be part of it, the debt is eliminated in full. And a lot of creditors don't choose to be part of it because they feel they're just not going to receive much back. For example, if a creditor gets a notice that the plan, the repayment plan, is going to pay 10 cents on the dollar, a lot of folks, companies, creditors don't feel it's worth their while to fill out the forms, be part of a plan where they might get 10 cents on the dollar towards the back end of a 3 to 5 year plan.
And so that debt then is completely eliminated.
Completely eliminated as long as it's an unsecured debt that would be dischargeable otherwise.
That would be dischargeable in Chapter 7.
Correct.
What happens, for example, with respect to the interest and all that stuff in a consolidation outside of bankruptcy?
Well, they try and cut down the interest. They try and work out payment plans. And they do have relationships with some creditors where that does happen. But the problem comes in by the fact that not every creditor is going to want to cut a deal and be subject to a debt reorganization or a debt settlement plan. Chapter 13, the creditor has to abide, and the interest is cut off. The only interest that a debtor pays typically is a 4 to 5% administrative fee that the Chapter 13 trustee gets for their duties of administering the payments each month.
So the interest is cut off then. What about late fees?
Late fees are cut off, interest is cut off, over limit fees are cut off. The creditor basically, we're talking about a credit card company here, basically files a proof of claim for what's owed. Let's say it's $10,000. They are paid back $10,000, and that's it. Sometimes less than that, but never more than that. They don't get interest, except in very rare cases where the individual has so much property that the trustee figures they should pay interest because they have the ability to pay it off.
And that's a rare and a unique situation.
Very rare. For the most part, there is no interest on unsecured debt except for the administrative fee that the trustee charges, which is very reasonable. 4 to 5% is not very much to pay.
4 to 5% on?
All dollars that go through the trustee's office for an administrative fee.
Actually monies that come through, so basically on your plan.
Exactly. Whatever the debtor pays in through the plan, the trustee has to get paid an administrative fee for the work that they do.
So if $10,000 comes through the plan, then they get paid
approximately $40 to $50 out of the $10,000.
So that seems seems really reasonable in terms of getting that done.
Very reasonable. And what they're doing is a lot of work. They're taking care of all the administration of the debts. They're reviewing the proof of claims. They're paying out pursuant to those, and they're doing this over a 3 to 5 year period. So it really is significant, and it's a great form of relief, Jesse, for people who have the ability to repay but want to stop the high interest on the credit cards and want to stop the collection efforts. Chapter 13 affords an individual an opportunity to do that, pay back over time with very little or no interest, and sometimes even pay back less than the full amount owed.
Well, Dave, so we could explain it to our viewers, for example, of having just this one huge pot right here. This is where all your bills go in, both secured and unsecured. Secured being the mortgage, being the car, unsecured being the credit card bills, medical bills, things of that nature. And so everything gets put in this pot.
That's right.
And then the bankruptcy trustee is responsible for these things in this pot. And as your money comes in to pay the fund the plan, whatever that amount is, then out of this pot, the trustee makes the payment to this creditor, that creditor, and this creditor, and this person. throughout the entire duration of the plan. So it could be several creditors. It could be 15 or 20 creditors coming out from just this one particular individual plan.
Right, and the trustee follows a certain code section called the hierarchy of claims. So in other words, domestic support obligations, maintenance and child support would be paid first. Secured creditors, mortgage arrears, autos, property taxes, those would be paid back second. And your unsecured debt, credit cards, medical bills, personal loans, past due utility bills, those creditors are paid last. So really, the most important creditors, family obligations, and then creditors secured by property get paid first. Credit cards, medical bills, personal loans, utilities, they get paid at the very tail end, and often less than 100%.
Do they ever, on the unsecured, go under 10%?
Yes, you can get a case approved where the amount paid back is less than 10%. It really depends, but typically not. You figure you're going to pay 10% at least, or more, depending on your ability to pay and what type of assets you have. So anywhere between 10 and 100% is what you're going to have to pay back through a Chapter 13 over time.
Let's talk about assets, because that's very important. The bankruptcy trustee needs to know that and wants to know that, and the bankruptcy attorney needs to know that in order to make a determination, in order to properly complete the voluntary petition for Chapter 13. So some of the things that you look at are just the basic things that make sense to everybody, which is going to be, how much do you have in your pocket? I can't tell you how many times people, they always put zero, most of the time.
Right.
And
sometimes it is zero.
And sometimes it is zero, true enough. In their bank account, it could be whatever it is. It could be maybe a higher amount, but that's because they have to pay for the rent and pay their bills. And so at this particular time when they've come in, that's what's in there. And so we go on down the list. They look at insurance. What happens if I have not term insurance is something I can't borrow against, but what happens if I have a whole insurance policy that I can liquidate and get $15,000 or $20,000? What's going to happen with that?
We can protect whole life insurance in either chapter of the bankruptcy. Chapter 13 for sure, because you're repaying. In Chapter 7, we could protect it too, provided that the beneficiary is a spouse or a dependent. So as long as the beneficiary is not a sister or a non-family member, then the money would be exposed. But as long as it's a spouse or a dependent, the cash value is protected.
When you say exposed, you mean that if it were somebody other than those two, they could liquidate it?
It could be liquidated in Chapter 7. But in the case that we're talking about, Chapter 13, all of your property is protected because you're repaying your creditors. So you can keep equity in a home, equity in a vehicle, and even money's in the bank. You just have to pay back through a Chapter 13 at least what the creditors would get if you did a Chapter 7 liquidation. That's the key. I'll say it again. You have to pay back at least what the creditors would get if you did a Chapter 7 liquidation.
So that applies to when you go down the line, for example, my retirement, which is protected?
Retirement is protected under both chapters of the Bankruptcy Code. So that would not be considered an asset. That would be protected under either chapter.
What about loans that maybe, before I filed this Chapter 13 bankruptcy, I took a loan out against my pension. And so now is that considered, an unsecured debt that I can pay back 10%? Or how does that work?
Well, if you take a loan against your pension, 401k, or other retirement account, that's your own money that you're borrowing. So you get to pay that back in full outside of the bankruptcy.
Outside of the bankruptcy, so it's not included in the bankruptcy.
Correct. It's not a creditor because it's your money that you borrowed against, and you have the ability to repay it while you're in a Chapter 13, but you do it outside the 13. It's not part of your plan payment.
What about other things? I know they look at your assets, they look at vehicles, they look at pets.
They look at pets.
If we look at Isabella, is there a little line on there that talks about the value of little Isabella?
Yes, but they don't want your pet. They don't want your domestic pet.
Well, what are they looking for, Dave?
What they're looking for are farm animals, horses, things that have value. In certain parts of the country, people file bankruptcy and they do have significant livestock, whether it be cattle, pigs, cows. I'm not a farmer, Jesse, so I don't really know, but where we practice here, the only kind of animal you're going to see is the domestic kind sitting on my lap.
Or horse, or a racehorse. But let me ask you this. I mean, there are breeds of canines that are show dogs, and you can pay, $20,000, $30,000, unless he or she can type and answer the phone. I don't know if I'm particularly interested in that, but in a situation like that where you have a pedigree, are they going to take my dog? Not in a Chapter 13, I understand.
No, they're not going to take your dog. In fact, I've never seen a trustee even show an interest in a dog to any extent. The only interest in animals, again, would be some kind of racehorse that had value. Maybe that was inherited from a father or a mother, or if there's significant livestock, a group of cattle, a group of cows, a group of pigs. That's the only time it would ever be a problem. And again, I wouldn't advise someone to file if they did have that kind of equity in animals. But they do have to be disclosed. It is part of the bankruptcy petition. And again, I believe that's because in other parts of the country, livestock and animals are more prevalent than in Illinois and Chicago.
What other kind of things, for example, in a Chapter 13, let's look at my car. You had mentioned a little bit earlier that generally there's no interest, that there's no late fees or over the limit fees or anything like that. So how does that relate to my car?
Well, if it's a finance vehicle, you're going to pay that back through a Chapter 13 trustee.
But am I going to have to pay back the interest that I originally agreed? Because the car is going to be paid back if it's financed throughout. By the time the plan is over, regardless of the duration up to the 60 months, it's going to be paid off. So, I mean...
No, typically no. You're going to pay about 6 to 9% in interest through a Chapter 13 on your car. It doesn't matter what your contract said in terms of interest. Here's the distinction. If you purchased the car more than 2.5 years ago, you're able to pay back the fair market value of the car in full.
I just want to make sure that I understand and that the folks at home understand too, that if it's purchased more than 2.5 years, and let's say I owe $15,000 on the car, but it's only worth $7,000, are you telling me and the folks at home that I only have to pay back the $7,000?
You'd have to pay back the $7,000 in full at 100%, at about 6 to 9% interest, and then the remaining $8,000, the unsecured portion, could be paid back less than 100%, typically 10%.
So that's what they refer to as a cram down.
They call it a cram down, exactly, because you're not paying the full amount that you owe on the vehicle. You're cramming down the creditor's claim from 15 down to 7 at 100%, and then the remaining 8 at about 10%, which could be $800. So $7,800 total instead of $15,000. It's a big difference to the creditor's bottom line.
I thought you were going to say you're cramming it down the throat of the creditor,
well,
which is what you're doing too.
They say that too, but I'm giving you the politically correct answer.
Very, very nice. So, again, what determines the fair market value? Because I know they're going to argue about it. The creditor or the debtor is going to argue about it, and the creditor are going to argue about the fair market value. They're going to say the fair market value is 7, or you're going to say that, and they're going to say, oh no, it's 15.
Right. Well, there's a couple big sources where they look to: the NADA, National Auto Dealers Association value, as well as the Kelley Blue Book value. Those will give some good reference points. Some cars have to be evaluated by an outside person if it's a special car.
So they have an appraiser essentially for the car?
On occasion, if it's some type of race car or antique, or an old enough vehicle where Kelley Blue Book doesn't even have a value on it. But for the most part, it's going to get negotiated. The law firms don't want to waste time and money going to a valuation hearing in front of the bankruptcy court. Typically, cooler heads are going to prevail. They're going to agree on a figure that both parties can live with, and it's going to be a compromise.
And in that valuation hearing, is it that one person puts on their expert or their appraiser and the other one puts on theirs? Is that how that works?
Yes, each party is going to have to bring in their expert.
And I'm going to have to pay my expert.
You are going to have to pay your expert, yes. And typically, like I said, it won't go to a full hearing because the creditor will cave, because the creditor doesn't want to bring in somebody who can testify as to the value of a vehicle sight unseen. They haven't even seen your vehicle yet. So how do they really know that that vehicle is a typical vehicle depicted in Kelley Blue Book? Maybe it's damaged, maybe it's excessive damage. I mean, it just can't go. So it doesn't happen. A valuation hearing rarely happens.
Because it's not financially feasible for them, and that's why they're willing to negotiate, because it's really going to save them money, or actually mitigate the amount of money that they're not going to get.
And bankruptcy is all about who gets how much and when.
Sure.
And they want to negotiate that down because typically these Chapter 13 cases won't go to completion anyway. So you don't want to waste too much money fighting over valuation when in reality only about 15 to 25% of bankruptcy cases under Chapter 13 Complete.
When you say that, and what I don't want to, I want to get back to the Kelley Blue Book, so remind me. But when you say they don't go to completion, what does that mean? Does that mean that they're dismissed? Does that mean that the debts are discharged? What happens?
Well, several things happen. A case will either be dismissed when an individual doesn't make the plan payments on time over a course of months.
Dismissed by
the trustee or by a creditor.
They'll come in on a motion?
They'll come in on a motion to dismiss, and from that point on, the creditors can pursue the debtor again. The other option is...
So they don't have the protection of the stay keeping them away.
That's right. And here's why, Jesse. You're talking about a 3 to 5 year payment plan for exactly what you have available per month. That is a tough road to hoe. And for a lot of people, Chapter 13 just wasn't a good option. They really didn't have the ability to budget and pay it back. And for those people, it was just a good college try that failed. But for others, for the 15 to 25% that succeed, those are people that typically lost their job and became employed again, were sick, now they're back healthy, or some other reason why they couldn't make their payment, and that's been cured. Those people can succeed with a Chapter 13, where other people who try a Chapter 13 just to save a ship from sinking when really the ship is already sunk.
Right, yeah.
So I don't want to scare people. Chapter 13 works well for a lot of people, but you want to meet with an attorney and see what your likelihood is based on your budget and based on your assets and based on your debt.
And you really want to try. You don't want to. You want to represent all of your information to the bankruptcy attorney, so he can make that, or she can make that determination and plug everything in and exactly see where you're at.
Yes, I have a lot of respect for clients who give it that college try, who don't want to wave the white flag and surrender. They don't want to give up their home if they're close to being paid, you know, in terms of the arrearage. So I give a lot of respect to clients who give it a try. Unfortunately, people lose their jobs in the midst of a Chapter 13. People become divorced in the midst of a Chapter 13. Things happen over 3 to 5 years. 3 to 5 years is a long time. 5 years ago, this Isabella here wasn't a part of my life. So things change. I say that to say because I didn't think I'd ever have a dog again. So things change, Jesse. 3 to 5 years is a long period of time. So you want to be very careful that you go into a Chapter 13 with an open mind that, hey, maybe this might fail, and that you want to have some backup options.
Well, let me ask you this. I mean, things do definitely change, but what happens in the course if it's dismissed because you haven't paid, and so basically now all the creditors come after you? What happens to the amount of money that you've paid into the plan?
Well, it does get applied to your creditors, whatever you paid in. And again, the credit cards are going to get paid last, so it's quite likely that a lot of your creditors that are the most aggressive in terms of collection,
which are the unsecured,
haven't got paid. But the good news, Jesse, you can take a second bite at the apple typically and try Chapter 13 once again, and that's called refiling.
Well, are there any downsides to that? So let's say that I couldn't make my plan payment because something happened. It was a change. I had a problem with my job, and I either got laid off or I had to take a lesser paying position in order to still be employed. And then now I find myself in a position, like you were saying earlier, that, hey, listen, that changed. Now I'm back. I've got a better job, and I'm making more money.
Well, sometimes you can petition the court for a modification based on your circumstances. So it really depends. But oftentimes, you know, you're going to have to refile.
Well, if I refile, what are there any downsides? Do I lose any protection? Or is it just exactly the same as I filed the first time?
For the most part, it's going to be the same. The attorneys have to do a special motion to extend the protection if you were dismissed within 1 year. But the real downside is you're going to have to take the credit counseling again. You're going to have to pay the filing fee again.
Everything again?
Everything again. It's a brand new case. It's Groundhog Day, Jesse. It's Bankruptcy 101 over again under Chapter 13. But once you do what you have to do, you really are afforded a second attempt to make your repayment plan. So it is a great thing to be able to do that and try and save yourself under another Chapter 13.
Well, let me ask you, suppose I did a Chapter 13, and after a couple years into it, we had a change in circumstances, and for whatever reason, it got dismissed. But now I'm in a situation where I can do a Chapter 7. Would I still be able to file that? I mean, because I just filed a Chapter 13 and was just dismissed?
Yes, you can always do a Chapter 7 as long as you haven't had a prior Chapter 7 within 8 years. So a lot of times circumstances change. Clients are in a Chapter 13. Things go south for whatever reason. They wind up converting the case to a Chapter 7, and getting that fresh start.
When you convert the case to a Chapter 7, what happens to all the monies that were paid before?
Whatever's been paid out has already gone to the creditors.
And that's it?
That's all they would receive, except for non-dischargeable debt like student loans, parking tickets, child support, recent taxes. Those debts are going to stick around. So even converting to a Chapter 7 will not take care of non-dischargeable debts. But you do get a great benefit by eliminating the dischargeable debts like medical bills, credit cards, personal loans,
right,
and utility bills,
we'll
past due utilities.
And before I forget, and I wanted you to remind me, and Dave, you
Kelley
did?
Blue Book.
That's right. There you go.
We're not out of time yet, Jesse.
We're not out of time. Good. What I wanted to, because when people do Kelley Blue Book, there are 3 different values. So what kind of value is the trustee really looking at? I mean, you have your resale value, your private party value, you have the trade-in value, and then the dealer value.
Yeah, we're typically going to go with an average of them, which is the middle. Not the highest, not the lowest, but what a typical value is, what the car is really worth, what it could be resold for. It's usually going to be in the middle of the Kelley Blue Book or the NADA guide.
Mm-hmm.
But we're going to come up with a value on the vehicle. We're not going to fight too extensively over that because it's really not worth it. We're not talking about a big difference between values sometimes between what the creditor wants and what the client wants. And we can usually agree on a compromise. Like all other legal cases, there's got to be a balance.
Well, Dave, when you think about the Chapter 13, people do it typically to save their home or even an auto that is behind because they need that automobile in order to get to work. Right?
Right. You definitely want to do a Chapter 13 to save a vehicle. You need that for transportation. You need that to get to your job. You need that to be able to make your mortgage payments, basically. If you live in a suburb or you live in a rural area, you definitely need a vehicle. If you live in the inner city, then maybe you can get by on public trans. But yes, Chapter 13, definitely very commonly used to save an auto, restructure the loan. In the example you gave earlier, a $15,000 vehicle, you're only going to pay back $700, $800 over time. At a lesser interest rate, that is a great savings over time. So it could be a financial tool for someone who is struggling to be able to keep their property and yet not pay back the full amount.
But pay back something.
Pay back something. Pay back what they can afford over the next 3 to 5 years based on their income minus their expenses.
Right, and then when you look at the planned kind of payment, and we've talked before about what's allowable, what's left after the allowable expenses, and those were some of the expenses we talked about. For example, your mortgage, you still have to keep your mortgage current in Chapter 13 because the amount that's in the plan is just the arrears.
That's right. You have to make your ongoing mortgage payment, first, second, third, however many mortgages you have, consistently, timely each month while you're in a Chapter 13. This is on top of the Chapter 13 trustee payment, which is going to be used to pay your arrearage, your vehicle, and all of your other debt. So it is a tough thing to do, but if we go through an analysis and we determine you have the ability to do it, we're going to recommend a Chapter 13 for that very reason.
Well, this has been very informative, Dave. I think that a lot of people out there are going to realize that there is a light at the end of the tunnel, and the dog days of summer has just begun.
Absolutely.
Right?
Chapter 13 is a great way to go. I want to thank you for watching Legal Action. On behalf of Jesse Barrientes and Isabella, my name is David Siegel. We'll see you next time on Legal Action.